For this assignment, the topic we choose was Principle of Determining the Market Value in Land Acquisition. The assignment consists of 6 cases, as stated in the introduction above.
Introduction, Section 3(1) of the Land Acquisition Act 1960 of Malaysia defines the scope and objective of land acquisition. The LAA 1960. The LA of 1960 permits the purchase of any type of land, but the purpose for which land may be bought are regulated by the purchasing body's constitutions. Land can be purchased by state authorities for any public purpose, including the construction of public railways, roads, and other infrastructure. Nusantara Daya Sendian Berhad. The respondent owned land known as Lot 46200, which was acquired pursuant to the LAA for the purpose of constructing a water treatment plant in southern Malaysia. The land administrator had awarded a sum of 60,560,800 as compensation for the acquisition. However, the respondent claimed that the fair market value of the land was 28,800,030 and 74.40 ringgit, which is 6,458 per 0.335 per square meter. A private valuer's report was offered in support. The respondent also claimed a loss of income of 40,200 ringgit for loss of use of the scheduled land as a car park for 67 vehicles. After making the necessary adjustment to account for the difference between the land and the comparable sales, the government valuer recommended a market value of 3,700 ringgit per square meter. The land administrator rejected the respondent claim for loss of income. Dissatisfied with the award, the respondent appealed to have the matter referred to the land reference proceeding before the High Court. In High Court, the High Court judge assisted by assessor pursuant to Section 40C of the LLA increased the amount of compensation from 16,516,800 to 19,026,907. Both parties provide comparable data in their respective valuers' reports. The High Court judge made adjustment to the values presented by the parties and stated his reason for such adjustment. The respondent appealed to the Court of Appeal as it was dissatisfied with the amount of compensation ordered by the judge. At the Court of Appeal, the appellant raised the issue of whether the appeal was limited to issue of fact on the ground of the quantum of compensation. The appellant submitted that the appeal was barred by reason of Section 49(1) of the LAA, as the three main issues really relied on by the respondent, namely the 10% dedication to market value, the double counting, and the potential development value of scheduled land were questions of fact. In essence, the appeal was to increase the amount of compensation, but such an appeal is barred under the provision in Section 49(1) of the LAA. In the Federal Court referred to Semenyih Jaya and found that the proviso in Section 49(1) of the LAA is not a complete bar on all appeals related to compensation. Instead, the bar to appeal in the provision is limited to issues of fact on the ground of the quantum of compensation. An aggrieved party may appeal against the High Court decision on a question of law under Section 49(1) of the LAA. The apex court then consider what is a question of law within the context or for the purpose of Section 49(1) of the LAA. The apex court decision clarifies the question of law expectations to Section 49(1) of the LAA. If left unchecked, appeals will be made against High Court decision and computations contrary to the proviso in Section 49(1) of the LAA. In this case, the Federal Court looked at the substance of the complaint against the High Court decision and not the way in which the complaint is framed. The Federal Court thus conclude the complaints are in substance about the computation of the award, how the education was said to be erroneously made, or certain factor not taken into.
So the case is Temih Jaya 9 Berhad v Pentadbir Tanah Hulu Langat. So the case fact is the appellant, which is Temih Jaya 9 Berhad, was unsatisfied with the compensation rewarded by the respondent, which is Pentadbir Tanah Hulu Langat, amounting 20,862,281 ringgit and 75 cent. So the appellant appealed to the High Court, and the High Court only approved the severance and injurious affection claim from the appellant. So, unsatisfied with the High Court's ruling, they tried to appeal to the Court of Appeal, but the Court of Appeal denied the appellant's appeal from the High Court's ruling. So, they appealed to the Federal Court, and the Federal Court granted the appellant's appeal. And the Federal Court reviewed the Section 40D of Land Acquisition Act that gives the assessor the authority to decide the amount of compensation. So the Federal Court found that it is unconstitutional as the Section 40D of Land Acquisition Act violate the Article 121 of Federal Constitution. So the Federal Court Judge Tan Sri Zainun Ali stated that the authority to grant compensation in land reference proceeding is a judicial power that should rightly exercised by the judge and no other. As the result, she held that Section 40D is violating the Federal Constitution and should be struck down. So from that moment, on 6 June 2017, the Chief Judge of Malaya, with Tan Sri Ahmad Ma'ruf, issued a new practice direction stating that this new Federal Court decision applies to all cases still pending and not finally disposed of. So from the Sembilan Jaya 9 Berhad v Pentadbir Tanah Hulu Langat, we can see the role of assessor has been changed from having a full authority in determining the amount of compensation into only aiding the judge. So I'm going to start from the initial role of assessor, which is before 1984. The role of assessor is only to assist or aid the judge. But then after the Act of A575, which came into force on 20 January 1984, the role of assessor was completely removed. So after that, by the Act of A999, the role of assessor was restored, and the role of assessor is gaining more power as the Section 40D of Land Acquisition Act, from being advisor to the fact finder and adjudicator. So this section empowers the assessor to decide on the amount of compensation to be awarded by arising out of the acquisition and the decision made. So the assessor have full authority and power to determine the compensation from the any land reference cases. But then after the case of Sembilan Jaya 9 Berhad v Pentadbir Tanah Hulu Langat, the Federal Court ruled that allowing anybody other than the judge to decide the land reference cases effectively overrules the power of the court and violating the Article 121 of Federal Constitution. So the decision from Sembilan Jaya v Pentadbir Tanah Hulu Langat applies to all cases and still pending and not finally disposed of. So finally, the role of assessor has been go back to the initial role, which is to aid and assist the judge in determining the amount of compensation in land reference cases.
Net Superintendent of Land and Survey Kuching Division versus Yah Inkai and Henok. Case fact. Respondent purchased land in Lot 358 Tanah Salak District for between RM 210,000 ringgit and 300,000 ringgit. The land subject to notice Section 47 issued by the Ministry of Resource Planning on 17 June 1997, which was published on 60 July 1997 for the purpose used for the Sarawak River Flood Mitigation Channel. In 2005, a portion of Lot 3-A in the Tanah Salat district was taken over for the Jalan Ramungan Highway project, and both of respondents were compensated at the rate of RM23 per square feet meter. The two lands were later declared as proposed road bypass from Sungai Sarawak to Batang. Now we turn to High Court. On 21st October 2011, investigation was held at the office of the Superintendent of the Land and Survey Department Kuching Division in accordance with Section 51 of the Sarawak Land Code, and the amount of compensation given to respondents for the resumption of the land was determined. Both of respondents accepted the award under objection and applied to refer the matter to the High Court under Section 56 of the Sarawak Land Code. So now, as declaration, the applicant resumed to the land through declaratory memorandum of exception of the land partition deed number L679/2012, which was duly registered on January 9, 2012, as shown in Appendix H on the statutory statement. The High Court decision addressed to the issue of compensation to be paid and how much compensation will be given on the value of the land on the date of the Sarawak Land Code. Section 47 notice or the declaration under Section 48 of the Sarawak Land Code. So, as decision in the regard, the Land High Court just has consideration both of this court decision in Jais Chief and Orth versus Superintendent of Land and Survey Kuching Division and Superintendent of Land and Survey of Samarahan Division versus Rento Abdul Hamid, where indicates finally contrary to the decision in Jais. This court determined that the material date to determine the amount of compensation to be paid is the date of the 47th notice, not the date of the Section 48 declaration.
For the next case is Northern Green Ventures Sdn Bhd versus Pentarbit Tanah Daerah Hulu Langat. For the case fact, Northern Green Ventures Sdn Bhd filed this reference to challenge the respondent's compensation for the taking of the applicant's portion of land located at Lot 899, Grand Mukin 1050, Mukin Cheras, Hulu Langat District, Selangor. The acquisition as for the project skim bekalan dan pengagihan air langat 2 fasa 1 package 15. The applicant's objection is focused on the following market value of the scheduled land. According to the applicant's valuation report, the respondent approved a sum of 5,980,635 ringgit and 50 cents. The applicant claimed that the correct award should have been 8,335,380 ringgit at a rate of 1,200 ringgit per square meter. Compensation for injuries affection in the amount of 5,440,000 ringgit for loss of development potential, 7,900,000 ringgit for cost of construction of a bridge crossing, and 519,805 ringgit to Sein for construction losses. The reason found in this judgment will be confined to the decision on the above claim. Go to background fact. The applicant is the registered owner of the scheduled land,
which was declared for intended acquisition by publication of Form D in the Selangor State Gazette on April 27, 2017, in accordance with Section 8 of the LAA 1960. The scheduled land has a total area of 40,974 square meters, of which 6,946.15 square meters are the subject of this acquisition. The scheduled land is a vacant parcel of residential land that is freehold. Following the acquisition, the scheduled land was divided into two plots. On May 16, 2018, the respondent had an inquiry in which all interested parties were present. The applicant's and respondent's valuation report were both considered. The applicant is unhappy with the amount of compensation awarded by the respondent. And we go to the reason for the decision. The respondent approved the claim amount because it considered the market value of the scheduled land provided by the applicant's valuer to be reasonable. As per legal representation for the applicants argue that the market value awarded is insufficient because the respondent arbitrarily decided to adopt the valuation report provided by the applicant without giving the JPPH valuation of 1,200 ringgit per square meter adequate consideration. Additionally, it was claimed that the respondent did not fully investigate the foundation for the awarded compensation. The respondent is required by law to conduct a thorough investigation into the value of the scheduled land and determine the right amount of compensation as stated in Section 12, Bracket 1 of the LAA 1960. Next is about severance and injuries affection. The land of the applicant has been divided into two parts, Part A and Part B, as a result of the acquisition. To the north of the scheduled land, Part A consists of a triangular portion measuring about 12,381.49 square meters, and to the south, Part B, a square of trapezoidal portion measuring about 21,646.77 square meters. The severance almost exactly cuts through the middle of the applicant's land, splitting it in half. In order to achieve this, the applicant has calculated that the bridge and all other structures will cost approximately 7,900,000 ringgit. Therefore, it was argued the applicant's total claim for severance and injuries affection, which amount to 13,340,000 ringgit, should be approved. Next, for the consequential losses. The consequential losses totaling 590,805 ringgit to cent. Claim consists of during inquiry before respondent and costs incurred for land reference at High Court. At the inquiry, the respondent allowed only the architect's cost of 13,000 ringgit and QS cost of 14,200 ringgit. The remaining fees were not permitted. Both assessors did not make any comment on this claim. As a conclusion, the applicant's claim for additional compensation for the market value of the scheduled land was denied by High Court for the reasons stated above. The severance and injuries affection claims were increased, but the claim for loss of development potential and other consequential losses was dismissed. The 3,000 ringgit deposit will be returned to the applicant. For the record, the fees for the two assessors were paid on the same day by the decision was issued.
Next, I will present about kes Persatuan Pemandu Perempuan Malaysia versus Pentadbiran Tanah Wilayah Persekutuan Kuala Lumpur. For the case fact, a portion of the land owned by the Association of Malaysian Female Drivers and recorded as state lease the title 1766 lot number 15297 in Kuala Lumpur district. For the appellant, solely for the lands worth of 423,270 ringgit or 4,000 ringgit per square meter. For declaration, when the respondent denied the appellant claim for compensation, the latter filed an appeal with the High Court under Section 37. For the High Court judge who heard the land reference order has concluded that the appellant is only entitled to compensation for the stance fence. For the decision, given the foregoing, we must draw the conclusion that the appellant's appeal lacked merit and reject it. Upon reviewing the appeal, we are unable to identify any reason to reverse HMT's decision due to either factual or legal inaccuracies.
Next, the case Johanda Realty Sdn Bhd and satu lagi versus Ketua Pengarah Jabatan Pengairan dan Saliran Malaysia and satu lagi. So this case fact is, this case involves Johanda Realty Sdn Bhd and another one versus Ketua Pengarah Jabatan Pengairan dan Saliran Malaysia and another one. So Johanda Realty Sdn Bhd and Lee Hui Siang, plaintiff, are aggrieved by the decision of the Judicial Commissioner Johor Bahru High Court MTJB, which upheld the judgment of the penolong kanan pendaftar in a damage assessment proceeding that found in favour of the Director General of the Malaysian Irrigation and Drainage Department. So the High Court, that the MTJB determined on that Johanda Realty Sdn Bhd, the plaintiff had effectively shown that the claim against D1 as well as that D3 was vigorously reliably for D1X, and it subsequently ordered that a damage assessment be convened and heard before the penolong kanan pendaftar PKP. The abbreviation D1 will refer to the first defendant and D3 will refer to the third defendant. The plaintiff has sued the defendant in a writ of summon and statement of claim alleging damage as a result enroachment on the property since 1957 up until the present. In actuality, the theory backs up the plaintiff's attorney claim. She also demand payment for the estimated RM40,000 cost of demolishing and cleaning the squatter settlement. The request to relocate the squatter was turned down by the MCO. The defendant action have caused the plaintiff to suffer a significant loss. The decision is that the defendant has to make repair and reimburse the loss suffered by the plaintiff. Thank you.